Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly phone call. I've had a crazy day today, so I'm going to try my best. I haven't had a chance to review the questions beforehand. I hope you folks are here. If I miss something, please do feel free to press *5. And when you press *5 on your phone, I can see that you have raised your hand. I'll be happy to assist. Okay, so let's get started with the questions. This is the first question is Sunil Kaushik, EB1C. This is the priority date pending 300 days. Is the I-140 approved? Approved, August 2018. Okay. And concurrently filed, so pending, yeah. So you can do AC-21. Yes, your jobs should be same or similar. Government has said, oh, just a second, somebody raised their hand. I'm not doing any new questions. If you have a new question, I won't be able to help you. But go ahead, you had raised your hand. How can I help you? Okay. Hello? I guess it was a mistake. All right, so we go back to the question. Yes, you can do AC-21 for EB1C cases. Because you are covered by 180-day pendency, even though your I-140 just got approved, you are protected under AC-21 portability. So you will be able to, even if they revoke your I-140, it shouldn't matter. You can do another thing. These days, Supplement J is approved beforehand. So you can actually file the Supplement J, which is your intention to change jobs, wait until it gets approved and then change jobs. So that's the easiest thing to do. *5 if you have a follow-up question on this. *5 if you have a follow-up question on this. Yeah, I don't see any issue here as long as the jobs are same or similar. You can step outside the conglomerate of companies that filed your EB1C and you should be fine. Okay, next question from Sandeep at 39. Family-based green card, wife is green card holder, H1B, got married in India. Oh, there is a hand raised. Guys, please be quick about raising your hands so we can. Okay, and this one is from. Go ahead, sir.
Sorry, this is Sunil.
Yeah.
There was a delay.
Yeah.
I just have one last question. So EB1 in the October bulletin yesterday is still retrogressed. I just wanted to check. So USCIS will continue to give me an EAD and advance parole as long as I apply for it.
That is
right?
That is
even
correct.
if it is retrogressed.
That is correct. Retrogression does not stop your right to continue to extend your EAD and your advance parole. Just make sure you file 180 days ahead of expiration every time.
I'm doing that, and now my L1A visa expiry max out has no meaning whatsoever.
It does not.
Got it.
Okay.
Got it. Thank you, sir.
Oh, you're welcome.
These were my doubts.
You're welcome. Good luck. Okay, going back to the question about family-based green card. So she's a green card holder. I'm on H1B, got married, lived in different states, New York and Tennessee. I-130 was submitted. They sent it to Chicago, where it was sent to California. Now, you don't get to choose where you want to file unless you are living in the jurisdiction. Okay? Guys, you have to, please, don't interrupt me once. Oh, man. Just keep your questions together, okay? I'm not going to, this is the, yeah, thank you. Do I put another application? See, I don't know how you can circumvent the processing times. Frankly, I have never done it. We don't go forum shopping. Wherever you live, certain papers can be filed from there. Wherever your wife lives, certain papers can be filed from there. There is one room for negotiation here. That room is which is your matrimonial home. So, for instance, if your wife lives in Kentucky and you live in California, but you get together more in California, can we say that's your matrimonial home? That's a little fuzzy. Nobody really knows the answer to that question. But I'm not sure I can give you any good recommendation. I don't think second filing is a good idea. I don't know of any law that stops you from doing that, but procedurally it would be a problem and you have to file where one of these jurisdictions falls. You live, your wife lives, your matrimonial home is. Other than that, there is not much room for a negotiation here. You cannot ask the government to move your application to a different service center. And Obamacare does not stop you from getting your green card. Those very restrictive interpretations about, oh, if you have taken public benefits, we are not going to give you a green card. They are still a proposal. They haven't been passed. They have to go through an entire process before they become law, or what would be called more accurately a regulation. So it doesn't work like that. You don't have to worry about taking Obamacare. That's not something you need to be concerned about. As to where it should have been mailed, where not, those are questions you can figure out. Just go to the USCIS website, see what the instructions on the form say. The other thing about notice to appear, that was never implemented. Government said, well, if we deny your benefits application like an H1 or an L1, we will then proceed to put you through deportation proceedings. But I think that's very impractical with millions of cases already pending. They have, 80,000, something like that pending, or is it 800,000? Lots of cases already pending. I don't think they can make that happen. So anyhow, NTA was not implemented. Yeah, I don't know what the cutoff time would be. I'm not sure there is a cutoff time because we don't know when the NTA, if the NTA is going to go into effect. Another thing is, once we get into the midterm elections and if there is a shakeup in Congress, then this high-handedness of this Trump administration is definitely going to be diluted. Somebody has a hand up. I think it's the same person, Florida. I'm going to make one exception this time, but I won't go back to a question I've already answered, guys. Go ahead, sir.
Hello?
Yeah, go ahead.
Yeah. Hello, Rajiv. I really appreciate for your service. My quick question is, this is Sandeep, by the way. You just went through my concern.
Right.
First of all, I would like to know, I don't know why my attorney has sent my 130 family-based green card only to Chicago. I was thinking that he would be sending to Vermont Center, where it would take only 6 to 7 months.
Okay.
Is that accurate that he sent it to Chicago?
I already answered that question, that all these, where the form should be filed, they are in the form instructions. You just go to uscis.gov, look it up. I don't keep track of that. My team does.
Okay. Sure.
Okay.
Yes,
Sorry about
that's
that.
all.
All right. Bye-bye.
Thank you very much.
Okay, so guys, remember one thing. In the language of technology, I don't code, I just architect. My job is to take care of the legal aspects. All the procedural aspects of all the applications are handled by people who are much better at it in our office than I am, because they really know procedures inside out. I'm the guy you want to call if you want to know what legal issues you are going to encounter, not procedural. I am very poor in those. I don't have to keep track of that. Okay, so then we go on to the next question. Krishna, I-94 expired, daughter's I-94. Well, Krishna ji, one of the things you have to remember is that unlawful presence does not apply to children under the age of 18. So if somebody is 14 years old and they stayed in USA unlawfully for 2 years, does that bar them from entering USA? No, because they are under the age of 18. But let's say they stayed unlawfully present from 14 onwards and they turned 18. Now their unlawful presence begins to run. What happened when they were children doesn't matter. That's as far as I remember. Okay. So your daughter's I-94 expired April 29th. The receipt date is April 26th. That's the date that matters. So her application was received on time. In fact, even if the actual physical receipt is a day early and USCIS entered the case in their system a day late, it's the day they physically received the application that counts. because the definition of filing under HCFR, I think 103.5, is that filing is upon physical receipt of the application. There was a time they used to take 4 or 5 days to enter the data in their systems. That was not the official receipt date. Official receipt date would be when they actually receive your paperwork. *5 if you have a follow-up question. She was not out of status. You're good. *5 if you have a follow-up question. Press *5 on your phone. Okay, let's go on to the next question. I have a valid H1 cap exempt till December 2019. Visa is good till then. Somebody filed a cap subject H1, got picked up, is pending. Can I travel? Yes, you can. Yes, you can. It's perfectly okay to travel when your extension or transfer of H1 is pending. It's a problem to travel if there's a change of status, H4 to H1 or F1 to H1. That becomes something you need to consider carefully. But extension, transfers, amendment allow you to travel. *5 if you have a follow-up question, and it should have no effect on your pending H1. Please discuss your case with your lawyers. I don't know the entire facts, but generically speaking, this is not a problem. I have 2 people with their hands raised. Let me see. One is from New Jersey. The other one is from North Carolina. Let's go to New Jersey first. Yeah, New Jersey, go ahead, please.
Hello, Rajiv. This is Rick. This is my question I posted. Thanks for going through my question.
Of course.
So my other follow-up question is, if I'm outside of the country and then if the pending H1 gets approved, while I'm coming back at the port of entry, should I have to show my previous, the new H1 or
Right.
just the current H1?
What you should do is have the approval, if not possible to FedEx, at least have it scanned and emailed to you so that you can show it at the airport. Show your old visa, but show your new approval, and make sure your I-94 is given coextensive with your new approval, not with 2019 case. Okay.
Sure. So in that case, would my current H1 be any way affected or
No, why would it
impacted?
be? Why would it be? I don't see any problem with it.
Okay.
So even
Take my
yeah, I don't see any problem with it, sir. Okay.
Okay.
But I do want you to talk with your lawyers, make sure everything else is okay, because the immigration law has so many little details. Anything that's slightly out of place can cause a lot of problems. I've been doing this for 30 years. Still, every day I learn something new. So you can imagine how much variation there is in the central themes. So make sure you talk with your lawyers.
I agree.
Okay.
Yeah, thank you.
You're welcome. Good luck, sir. Okay, let's see who was next. All right, I can't. Here we go. Okay. Next one was North Carolina. Oh, there's 2 more. That's what confused me. But there's North Carolina and Texas. So let's go to North Carolina. Yeah, North Carolina. Go ahead, please.
Hi, this is Arpit from Charlotte.
Yes, sir.
I had a follow-up question regarding the traveling part from H1 to H4. And just want to confirm that can we travel or not while the application is pending?
See, H1 to H4 is an easy answer. Why? Because even though when you travel, your H4 application is abandoned. But you can just walk into the consulate, get H4 visa stamping and come back. H4 is an exception. You don't need an approval from USCIS of your H4 petition to get an H4 visa, unlike H1. H1, you first need a USCIS approval. H4, you can walk in and get stamped based upon the H1 approval.
Understood. Thank you.
You're welcome. Let's go to... Okay, this one is Texas. Yeah, Texas, go ahead, please.
Hi. Thank you, Rajiv, for your service. My question is actually, So my my H1B is approved till December 2020, but I didn't go for stamping. Now I have a new job offer, which is much better with the continuity of job. So I took that offer, and that employer has applied a month ago for transfer, but I don't have the receipt notice yet. So I'm still with the old employer, but I'm planning to start working at the new place once I get the receipt. So that will happen somewhere around in October.
Okay.
And me and my wife also has asked for till December 2020. So we both plan to go to India in December because we have some legal issues, property and stuff to take care.
Okay.
So I'm not sure what we should do. Like, how can we go for stamping, or we should not go, or just go to Canada and stamp it?
Okay. Currently, you are working with employer X, and you have an H1B transfer filed through employer Y, correct?
Right.
Okay. Now, you want to join employer Y when you get a receipt, correct?
Right.
Okay. Do you have a visa stamping on your passport?
No, I just got approval with employer X in June till December 2020.
I would not want you to travel until the second case is approved. The reason is, it's another fuzzy area. Nobody really knows what to do with it. When you are in the process of leaving the first employer, you have a transfer pending and you go for visa stamping. Consulates will try every possible way they can to deny your case anyway. So don't create a complication. My advice would be, and remember, I am not God. I'm just a human being making some educated guesses here, because this is not an area of law that is covered by any particular provision. All I can tell you is from my experience, they will try to delay you or deny you if you transfer, if you leave under these circumstances. Traveling itself is allowed. If you had a visa stamping, you could have used it, gone and come back, no problem. But because you need to get a visa stamping and you're kind of in a limbo stage, don't do it.
Right. So just last thing is, how about, I have master's degree from US, so how about if I travel this month to Canada and get a visa stamp, because I'm still with my old employer?
You can. If you get a visa stamping while you are still working for the old employer, I don't see any problem with asking the Canadian consulates to give you a visa. Can they raise an issue about, can they raise an issue while you have an H1B transfer pending? I do not know the answer to this question. Normally, I tell people not to travel in these circumstances.
Okay. All right. Not a problem.
Good luck.
Thank you, Rajiv.
Good luck. Bye-bye.
Bye-bye.
Okay, folks, some of you joined just recently. Please, I won't have time for new questions. I will only have time for answering the questions that are posted and follow-up questions from anyone related to the issue that I've discussed. Amit Arora ji wants to, he wants to get an L1 visa. Amit ji, what you may want to do is send me an email to help@immigration.com. help@immigration.com. I might do a specific call just for you. We could do it on Skype, and I'll record that call if that's okay with you. If I record the call, we won't charge you a consultation, but we'll make the call available for everyone so they can see how this process works for small businessmen. I think small businessmen need to be made aware. Bigger businesses have a lot more resources. They can reach out and do a lot of things that smaller businesses cannot, but you may have a possibility. There was a time just a couple of years ago when we did a whole series of L1s for smaller businesses. One business I remember was a jewelry store. That case got stuck, but there was another case in which this guy was I think a tier 2 internet provider with just 3 employees. Not only did we get his L1 processed, we also got it extended, and he ended up buying a 200 employee company in USA, and now we are doing his EB1C green card. So there are options here that you need to know about, and I need at least half an hour to go over them with you. So just send me an email to help@immigration.com. If you want it to be a private conversation, you can always pay for our consultation, and we'll be happy to lay out the plan for you. Most of the information that I'm going to give you is already laid out in our frequently asked questions. But still, it may be a good idea to talk, and we'll be happy to lead you through the various steps. Star 5 if you have a follow-up question. Star 5. Okay, let's go on to the next one. This is P.T. Ravi Shah. I have my H-1B visa stamped till 2020, wife's December 2020. I want to switch employers. I have to visit India due to some legal issues in December. Oh, I think you just talked with me. I think you just talked with me. So the answer that I just gave to the other person, if you are not this member of our community who just asked me a follow-up question, I would advise you not to go because you need visa stamping. So I would rather you wait until your transfer is approved. They do intend to reinstate the premium processing in February next year. So you can always premium the pending case. Star 5 if you have a follow-up question. Press star 5 on your phone if you have a follow-up question. Next one is GVS. Query on my current H-1B validity. Both renewal and amendment were applied together. Renewal is good till August 2019, but amendment is good till January 2017. That's an interesting, weird kind of situation. I think what you need to do is, you should definitely have your lawyers call the USCIS and find out what is going on here. I can make a guess. But it's not good to make guesses in these cases. It's your career, it's your life. Have your lawyers open a service request with the USCIS. And normally they are able to talk with the adjudications officers who can then inform you what is going on in your case. Okay, so yeah, that's a 6-8 month difference. It'd be good to know which one is it August 2019 or December 2018? You file them both together and you have different time periods. I think it's reasonable to reach out to the USCIS. That's what I want you to do. Star 5 if you have a follow-up question. Star 5. Okay. So let's see, we have a follow-up question. I'm trying to figure out which city you're from. Okay. It is New York. Okay. Let's get New York on the line. New York, go ahead. You're on the phone.
Hi, Rajiv. Thanks for taking the question. So basically, as you mentioned, it was actually applied at the same time with the same receipt number. So do you think that I have to reach out to USCIS to actually get this validity of my H1?
Not you, your lawyer or your employer.
That only.
Yeah, remember, they won't talk to you because you are the beneficiary, not the petitioner.
Okay.
Although,
and how about I-94?
I-94, assume that the earlier one is the one that's valid. Okay. So you have one which is good till December 2018. Plan that that's the valid one.
Yeah.
Don't take a chance with this. Okay. So what I would want you to do is, but they should be able to straighten that out with just one phone call.
Okay.
Okay.
Cool. I got it. Yeah. Thanks a lot. I got it.
Bye-bye.
Thank you.
Yeah, we have one person in our office who does nothing but make phone calls to the USCIS all day. Some of these issues just can't be resolved without understanding what the government did. NL Raza, guys, there is a question towards the end about DV lottery. I just want you to know, I didn't get a chance to read all the questions, but I was just skimming through. I'm not able to give you much information on DV lottery. We have never filed a DV lottery case. Did one or two about 20 years back when this thing first started. Then we realized you don't really need a lawyer for DV lotteries. The only time you need a lawyer is if you're trying to sue the government for an adjudication within the same fiscal year and it's a 485 filing. There you might need a lawyer, but normally you don't need a lawyer. So I don't know about DV lottery. If you are waiting to hear that, please hang up. I won't have an answer for you. Now, You have a question, NL Raza, about somebody who's been deported, your father, and you are asking about waiver of ground of inadmissibility. I don't know the answer to this question. A lot depends whether this was an aggravated felony or not. I would have to know a lot more about your case. Let's see. You also had firearms. Sentenced to 15 months. So it was definitely a felony. Is it an aggravated felony? I think marijuana over 30 grams becomes an aggravated felony. I could be wrong because I don't know if there's any waiver against aggravated felonies. I don't think there is. From what I remember, aggravated felonies, see, there's misdemeanor felonies and aggravated felonies. Aggravated felonies are a permanent bar from entering USA. Is there a waiver available? I haven't done one. I don't remember it off the top of my head. Normally, 99% of our cases go to misdemeanors or felonies. But there's a separate set of rules against aggravated felonies. So just double check that. I don't have the answer off the top of my head. I would want you to talk with a local lawyer where you are. Somebody who does deportation cases. Might be worth it to just take a consultation, just to make sure you're going in the right direction. Otherwise, you could file the 601, keep waiting for months and months and months, and then realize this was the wrong thing to do. Because this is an aggravated felony, this kind of waiver is not available. So that's the best I can tell you. Star 5, if you have a follow-up question on this, star 5. Okay. This is premium processing, no more RFE'S. This is Gokul Srivastava. Project will be ending in September 25th on H1B. Employer B is filing on September, or you got a job on September 6th. They have filed for an H1B transfer in premium on September 7th. Or they won't accept, they will reject the case without the LCA. If you don't have an LCA, they will reject the case. Okay, that's been my experience. If they are exceptionally kind to you, good for you. But I can tell you this, that I have never known of an H1B case survive if it is filed without an LCA. So I think they should file another case for you, and they should file it. And problem is, they've got to file it before September 25th. So that way you can continue working when the case is filed. If the case is received by the USCIS before September 25th, you actually have a 60-day grace period. But the problem is, the 60-day grace period works like this. It is the lesser of 60 days or time remaining on your I-94. So I don't have all the facts, but I think a second H1B filing is a very good idea. This one is going to get rejected. I don't know who gave you that advice that you can file without the LCA. I doubt it very much it's going to go through. They won't get an RFE, they'll just get a denial as far as I know. Now, I have not personally experienced, but there might be a little room to argue. We had a case in which one page of the LCA was missing. That can happen. Our office made a mistake. We forgot to put in the first page. They did send us an RFE, and we are responding to it. But that was a relatively minor mistake. But if you have the whole LCA missing, I don't know if they're going to send an RFE. If they do, great. Maybe your lawyer has some experience with that particular aspect. But even there, if the LCA was not approved as of the date of the filing is the physical receipt by USCIS. So when USCIS physically received your paperwork, if your LCA was not approved on that day, they will definitely send your papers back. Now, file another H1B. That's what I recommend. Star 5 if you have a follow-up question. Gokulji, if you have a follow-up question, star 5. Okay. Next question is Arminder. My current status is H1B, working directly with US employer. I-140 is done, priority date is 2012. Current H1B will expire 2019. Canadian PR. Okay. They are open to allow me to work from Canada. That's very good. While working from Canada, will I be able to maintain my H1B status? The answer is yes. You don't have to, but you can. H-1B laws don't require you to be present in the US. They only require that when you are in the US, you must be paid and you must work according to the H-1B that you have filed. I don't see any extension issues either, or any green card, because you're still working for that employer. Talk with your lawyers. I would not want you to be reckless about it. This is just a 3-minute consultation. Talk with your lawyers, understand the issues, but personally, I don't see any problem with doing this. *5 if you have a follow-up question. *5. Okay, there are 2 questions. 2 people have raised their hands. Let's see. One is, there are 2 people, Illinois and New York. So let's see which one comes up first. Area code 630. Go ahead, please. 630.
Hi, Rajiv. My question is, when somebody is working from Canada and if they are trying to maintain the H1, do they need to have the employer based in US?
Oh yes, H-1B cannot be filed or processed or maintained by a non-US employer. You have to have a US employer.
And the work that's being done for that employer, does the work have to be US client related as well, or the work can be for a Canada client?
You have to split these up. I see, Arminder, I see you are also on the phone. I hope this helps you as well. I'll actually unmute you also. Arminder, I'm unmuting you. Okay. Both of you are unmuted right now. I hope I didn't screw this up. Hang on one second. Just want to make sure I got both of you. Yeah, I think so. Okay. So going back to what the question presented was, I hope I didn't hang you up. I don't think I did. I know Arminder is on the phone. But this is the way it works. You have to split your work into 2 different geographical locations. You have work in USA and you have work in Canada. Technically, you don't even have to be working for the same employer in Canada. You can be working for anybody. But when you come to the USA, whether you come for 1 month, 2 months, or 6 months, at that time you are working for a US employer strictly according to the terms of the H-1B. There is one difficulty with this scenario. That difficulty is this. If you are not working for that employer while you're in Canada, at the airport or at the border, Customs and Border Protection can take the position. It does not look like you are working according to the terms of your H-1B. So if I were handling this type of a case, I would probably put it down in the paperwork somewhere that, hey guys, he's going to work on H-1B, but he will be working periodically. The periods are not fixed. I actually have a client in this situation. He's an environmental engineer. He lives in Canada, but every few weeks he comes to USA and spends a couple of weeks visiting clients because they do site remediation. So he's got to go to different sites. So while he's in USA, he's being paid strictly according to the US salaries, but this company is actually paying him US salary even in Canada. So not only is this a theoretical possibility, it's actually practically done all the time. Just make sure that when you are in USA, you are working according to US standards. Any follow-up questions on this? Hey guys, any follow-up question? Arminder, I can hear you if you want to talk. Arminder ji? Okay, I hope I didn't screw this up. Let's try it again. Okay, 2 people got hung up somehow. Either their questions got answered or I messed it up. One of the 2. Okay, it's Arminder again. Select. Hello, Arminder.
Hey, Rajiv, can you hear me, please?
Yes, I can hear you fine. Go ahead, sir.
Yeah. So I have one. In case, let's say, my employer, he said you can work from Canada, and my only follow-up question here is, once my extension expires while I will be in Canada, will there be any issue while I will be entering back to US? Because there might be a situation my original extension expires, and then I'm entering a US. The port of entry, they might ask, okay, how you are entering a US?
Of course. So you have 2 choices. If you're entering for non-work related reasons, you come on a tourist visa. But if you are entering for work related reasons, I would suggest that you keep your H1 extended and renewed. Why not?
But can that be done from I'm physically in Canada? Can that be done?
Yes. Only thing is, before you come to USA, if you are not a Canadian citizen, you would have to go get a visa stamping just like everybody else. So your H1 extension will be filed while you're living in Canada. When the extension is approved, you'll go to the consulate, get your visa stamping, and then come and go as you please. The only caveat is when you are in the USA, you'll be paid US salary and work according to US standards as described in your H1B.
Okay. Yes, that my employer is ready to, even he is ready to pay me a US salary. Everything will be exactly same.
Yeah.
Location will be same.
I've got to run, guys. I'm sorry, I'm running out of time today. Arvinder, good luck, okay?
Thank you. Bye.
I just realized it's 1:11 already. I have a bunch of calls scheduled at 1:30. So I've got about 19 minutes to go through 7 questions. Let me see how many I can get done. I'll finish the ones that I have here. May not be able to do follow-up questions. I'll do my best. So Anupam Boston, filed 485 based, Anupama it is, based in, it's Preeti actually. Oh, this is very confusing. Name is Preeti. I filed my 485 October 2017. Husband's approved DP1A. Got married before he filed his I-140. Could not apply for 485 because of J1. 485 interview is already done. I'm just waiting for my visa number to be available. Currently on H1B. I'm leaving employer, take a break. I'm a physician scientist. I was wondering if there'll be any issue for not having any job. See, you are a derivative beneficiary. You're not required to have a job. You can sit at home and still get processed for the green card. No problem at all. Oh, no. You can just chill out. It's no problem at all. Easily you can take a couple of months break. No problem at all. Guys, I'm not going to ask for follow-up questions. I just want to finish these. And if there's time remaining, I will answer more because I've got about 10 minutes left. And really, it's not a whole lot of time. Sorry about that. Very, very busy day. And you can thank Trump for that. Arpit Sept, my H1B extension got rejected. I'm sorry to hear that. Converted to H4. Okay. Is it possible for any other employer to file my cap exempt H1B? No, I don't know what you're talking about. H1B got rejected in March 2018. Then I got converted to H4. See, if you filed your application for H4 change of status before your current status expired, you're okay. Otherwise, you could be flirting with some very problematic issues, including unlawful presence. Of course, anybody can file your cap exempt H1B. My only question is, was your H4 timely filed? And if it was not timely filed, you could have a major issue. Please talk with a lawyer right away. Make sure there is no problem. Most of these problems are time oriented. So if you leave USA early enough and just come back with an H4 visa, that would take care of the problem. But don't leave without talking with a lawyer first. Yes. And by the way, you are not subject to the quota for 6 years after your H1B approval. So even if you went on to H4 for a couple of years, then you wanted to come back on H1, you would not be subject to the quota if your first H1B was a quota application. Okay. So let's go on to the next one. Pankaj Kulkarni. First H1B stayed in USA from Jan 2012 to Jan 2013. Expired August 2013. Joined new employer. Transfer initiated. Next H1B approved. Valid till November 2018. I have not traveled. Join new employer. Planning to transfer second H1B but waiting till Feb 2019 from premium. Is it okay to do another transfer? Yes, you can do as many transfers as you like. And even if you have not traveled, no problem. I don't see any problem here at all. You're not required to get a visa stamping. As long as you've been getting I-94s with every case that you filed, there is no issue. Next question is Red Devil. H1B extension petition filed in premium processing in July. RFE issued. RFE response submitted September. I think they will do your RFP premium processing. Even though they have said that they reserve the right, if they are not able to do something premium, they'll refund your money. I think you're so close to the edge. My guess is they'll give you premium. does the applicant have to go back to home country? I think in your situation, because your I-94 would have expired, you would need to travel out. There is no update on NTA. There's still nothing on that. It's not been implemented. Next question, also Red Devil. Guys, try to post one question at a time because we just don't have enough time. Oh, it's the same question twice. Yeah, oh good. So I can go on to the next one. Krishna, employer filed H-1B extension California under regular. Am I eligible for premium processing? I have on LinkedIn page, on my LinkedIn page, and you can see all our social media links on immigration.com. On the top right, we have icons for all my social media, Facebook, Twitter. I'm the most active on Twitter, Facebook, and LinkedIn, but also Google+. So if you go to LinkedIn, I have posted a graphic that explains to you who can get premium and who cannot. I don't see how you can get premium processing. I don't see how you can. Current processing time is 5.5 months. My I-94 expired April 2018. Should I leave the country after December 2018? Why? You have a case pending, right? And you can continue working for 240 days after April when your I-94 expires. Okay, so I don't see any problem with that. We have a 240-day extension to continue working. Okay. My wife applied for F1 to H4. So if we leave in December, you can always get H4 visa stamped. That's not the problem. So in your case, I don't see, if your H1B extension was timely filed, you have a grace period to continue working up to 240 days after your I-94 expires, so almost 8 months. And after that, if it's still not approved, it should be in February, you can upgrade it to premium. If it is still not approved, you can sit at home, not work after 240 days, but you are still legal to stay in the United States. Okay, let's go to Rakesh's question. I'm on H-1B. It is expiring in the month of December 2018. Subcontracting EVC model. Current project is ending in December. 2 questions. They're going to file an extension for an in-house project. Same client, but work location is different. Can we file premium? See, I don't, personally, in my mind, that's not an extension without change. Because extension without change out of Nebraska, I think is available for premium processing. Or if you are doing a quota exempt H-1B, you are allowed to get premium processing. If my current contract gets extension, change in salary level could be considered to be a change. It depends upon the amount. My guess is if it's 3 to 5%, 6 or 7%, maybe even, you can at least claim that it's an extension without change. Yeah, right now, as far as I remember, there is only 2 circumstances in which you can get premium. One is if you are doing an extension without change out of Nebraska, or if you are doing a quota exempt H1. Okay. So last question. Oh, this is the DVU. Okay. Now, guys, I have about, let's see, 5 minutes left for questions. Let me see how many I can get. Go ahead and press star 5. Press star 5 on your phone. Let's see how many I can get. So in the order that you logged in, let's begin with Texas. Texas, go ahead, please. Texas.
Hi, Rajiv. This is Rakesh.
Yes, sir. Go ahead.
I have a question regarding cap exempt H1B. So if the current H1 gets rejected, and then if I decide to move back to H4, if there's an employer who can sponsor my H1, will I follow the cap exempt, or do I have to go through lottery again?
No, if you have had, assuming that you had an H1B, quota H1B approved earlier, and then if there's an extension filed and that gets rejected, you are not subject to the cap. Okay. Not subject.
Okay, understood. Okay, I also have one other question. So, I currently have a H1 extension in process, and then my I-94 is actually going to expire in a couple of days. Is it okay if I travel back to my home country if my I-94 expires and my pension is still in process?
I don't think you can. If you have an I-94, I'm not sure. I'll have to look at the law. Obviously, if you had the I-94 time remaining, you could have traveled. But if you have an I-94 expiring, I'm not sure you can travel. Sorry, I can't answer that question. Okay? Let me take my next call.
Thank you.
Good luck. Okay. There's a lot of raised hands, guys. I'm going to try to do the best I can in the 4 minutes I have left. So let's go on to... Oh, man. Today was a very busy day. Okay. 3 raised hands. Again, in the order that you called in, North Carolina. North Carolina, go ahead, please. North Carolina, go ahead.
Yeah, hi. This is just a follow-up question on the previous question regarding the. This is Arpit State, question number 13.
Mm-hmm.
So, if the H1 was filed within before the status expired, that means before July or July of last year. Is that what you meant in your last statement?
Let's see. H1B extension got rejected in March 2018. Then I got converted to H4. So, did you already get an H4 approval, or are you
Not yet.
Not yet. When did you file the H4 approval? When did you file the H4 approval?
H4 was filed in March. It is still pending.
March 2018? No,
H4
hang on. March 2018?
Yeah. Within 10 days of rejection of H1.
I think you do have that grace period. I will have to look at the regulation, exactly how it operates. I think you do have that grace period. I think you should be okay. But please don't take my word for it. Have somebody take a look at that regulation very, very carefully, because the downside of this is if it is not done right, you could be accruing unlawful presence. Okay. I think you're okay. This is my best guess. Okay.
So any other employer can do my H1?
Any other employer can do
that you're getting? Because that's my question.
They may not be able to get you change of status. The way this works is, I guess you are the last question I'm answering. Sorry guys, I've got to go. The way this works is, in order for you to get an I-94 within USA, on the date they decide your H1 application, your H4 must be already approved. If the H4 is still pending decision or it is denied, they won't give you an I-94. They'll make you go outside USA for visa stamping. Okay?
Okay.
Good luck.
As long as I get approved.
I gotta go.
Right.
I gotta go. Bye-bye.
Thank you.
Okay, I'm still gonna try 2 more questions. I have 2 more people with their hands raised. I hate to just ditch you guys. Go ahead, Connecticut, go ahead. Make it really quick, please, Connecticut.
It's maybe a simple question to you, Daddy. So we have an H1B premium process. It's amendment plus extension.
Okay.
We got an RFE. The RFE was responded by our attorneys. However, Daddy, one of the exhibits was not sent through a fax, and we realized immediately and resent the fax on the next day. So if they consider that exhibit also, that is a very important exhibit in the context of RFE.
They might. You can certainly try. Was it received by the government after the time of the RFE had expired?
No, before the time.
I think they might just accept it. Okay. Good luck.
They'll accept it.
Bye-bye.
Okay. Thank you so much. Bye.
Last question. Pennsylvania, go ahead, please. Make it quick. Pennsylvania.
Yeah, hi Rajiv sir, this is Rakesh. So this is regarding the H1 extension on premium process. So if I am filing the extension the same way which I did with the previous H1, the only change is that previously I was on the LCA, it was put it as $50 per hour. But now I am getting around $70 per hour.
Oh, that's too much.
So can we put the same?
That's 40%. I don't think that's an extension without change. Okay.
Can we put the same number on the LCA and have the pay stub running on 70? Will that be fine?
I am concerned about it. It appears to me to be inappropriate Normally you can have a bonus, but if it's a fixed bonus, then it is considered to be salary. If it is a variable bonus, then it's not salary. Okay?
Okay, got it.
Good
Yeah,
luck.
thank you, sir.
Good luck, sir. Guys, I'm so sorry. I have to run. I have a call scheduled in 5 minutes. And like I said, thank Trump for that. We'll be talking again in 2 weeks. Good luck, everyone. Thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.